In this video, I'm going to reveal when it's against the law for your employer to lay you off. If you're not aware of the difference between a legitimate layoff and an unlawful one, you might lose out on an enormous amount of money. My name is Branigan Robertson, and I'm an employment lawyer. Let's talk big picture here for a moment. A layoff is when a company fires a worker, or more commonly, a group of workers, because of poor economic conditions or a lack of work. The company is having money problems, right? Which necessitates they fire employees because they can't make payroll, to the effect that implies that the worker didn't do anything wrong. The company is simply laying them off because they cannot afford to pay their salary, right? So that's the kind of common definition of what a layoff is. And please don't misunderstand me. Genuine layoffs are perfectly legal. And that's primarily due to the at-will laws that exist in most states. Most people who get fired or, quote, laid off do not have a case. But some do. And in rare circumstances, those cases can be worth millions of dollars. So you're going to want to keep watching because I'm going to show you when the law is broken and when it's not. And when you might be one of those lucky individuals who has a case that's worth millions. The first reason why your layoff may be unlawful is if the company lied about the layoff and fired you not because of poor economic conditions, but because you engaged in a protected activity or an activity protected by state or federal employment law. Here's a good example of what I mean by this. Let's pretend you're an engineer in California, where I practice law. Let's say that you've worked for a company that manufactures engine parts for airplanes, and you've been doing it for 20 years. And one day, you discover that a vendor's aluminum that was shipped to you doesn't have the minimum tensile strength necessary for the part your company is manufacturing. So, being a smart engineer, you send an email to the owner of the company and say, hey, we can't use this aluminum. It's not safe to put in airplane engines. But you find out later from your coworkers that the owner is pissed at you because your complaint will cost the company time and money to go back and get the right aluminum. 1 week later, surprise, surprise, the owner of the company sits you down and lays you off, saying that the company is struggling financially and needs to cut costs. So you ask the owner, is anybody else getting laid off? And he says, nope, just you. Well, in California, it is absolutely against the law for a company to fire an employee because he or she made a bona fide safety complaint. That is absolutely against the law. Complaining about safety is a protected activity under both California and federal law. In a case like this, your lawyer is going to have to show that the company lied to you when it said it was laying you off because of struggling financial situation, and that the real reason for your termination is the safety complaint that you filed. And there are all sorts of other protected activities like this. And employment law, right? There's refusing to break other laws, complaining about unlawful discrimination or unlawful harassment, reporting safety violations to OSHA or other governmental entities, reporting environmental violations, requesting FMLA, and the list goes on and on. So if you got fired after you made some sort of complaint or engaged in some sort of activity that you suspect is protected by law, your layoff might be unlawful. At this point in the video, I should mention that anything I say in this video shouldn't be construed as legal advice. If you need legal advice for your situation, you need to pick up the phone and call a lawyer in your state. I'm a California lawyer, and the free consultation process at my office is for California workers who got fired from their job and they believe that they have a case for wrongful termination, retaliation, harassment, or discrimination. If that applies to you and you think I've earned your call, please don't be afraid to call us for a free consultation. The second reason why your layoff may be unlawful is if the company lied about the layoff and fired you, not because of money problems that the company was having, but because you are a member of a protected class or category under state or federal law. For example, under federal law, it is illegal to fire a worker because of that employee's race religion, national origin, disability, or sex, which includes pregnancy and sexual orientation. Many states like California have a much longer list of protected classes, so your individual state law matters. Here's an example of how this plays out in the real world. Let's say you're Asian and you work as a plumber for a builder of new home construction. After 5 years of satisfactory job performance, you get transferred onto a new team that is entirely Hispanic. And your new supervisor makes no bones about the fact that he's not happy that you're here. And he and other Hispanics on the team make derogatory and racial comments towards you on a regular basis. But you've got a thick skin and you're not afraid of these guys, so you submit a few appropriate complaints in writing to HR. But HR doesn't really do anything about the whole situation. And 6 weeks later, the company does a reorganization and lays off one person per team for a total of 10 people. You just so happen to be the guy selected for layoff from your team. And you find out later that your Hispanic boss was the one who made the decision on who to lay off. In a situation like this, it's very possible that your layoff is unlawful because it's more likely that you were selected for layoff because of your race than a random selection by some corporate overlord. So if you believe that your layoff is driven not because of economic issues, but because of a protected class or category that you happen to be in, your layoff might be unlawful. Okay, Branigan, how do you prove that your layoff was unlawful? Because making the allegation that your layoff was illegal is really easy. Proving it is another matter entirely. So what does your lawyer have to do to win an argument like this? Well, there are two things unique to layoff cases that need to be proved. Number one, you need to show that the company is lying. Your lawyer will have to show that the company lied about your layoff. Remember, layoffs by themselves are perfectly legal. That is why companies are so quick to say that something was a layoff when it actually wasn't. It's a way to cover up and hide bad behavior. In the legal community, we call this pretext. Your lawyer is going to have to build a case that you were uniquely selected for layoff because of something protected by state or federal law. And this usually comes down to figuring out who the decision maker was and doing a ton of work to expose their bias and lies. Good lawyers do this by reviewing the decision maker's emails and text messages and by gathering statements from other employees that build the case that the decision maker hated you because of your protected activities or protected class. Your lawyer is going to have to wade through all the HR and corporate nonsense that they're going to come up with and throw at you and be able to explain to the jury a simple and coherent story. Number two, you're going to have to show that you wouldn't have been laid off otherwise. Your lawyer is going to have to build the case that you would not have been fired. And this is where layoff cases get really difficult. When the company is laying off hundreds of people at the same time, it's very easy for lazy jurors or judges to make the assumption that you were going to get the axe anyway. Mass layoffs, by their very nature, make proving unlawfulness difficult. Retaliation and discrimination, it becomes difficult to prove. So the challenge for you is going to be to find a lawyer who has the time, energy, and ability to chase down all the reasons why you wouldn't have been fired, even though mass layoffs were occurring. Your lawyer is going to need all your good performance reviews. He's going to need testimony from other employees saying that you were amazing at your job. And he or she, your lawyer, is going to have to convincingly destroy all the garbage arguments that the defense lawyers are going to come up with and throw at you. That you were lazy, that you had a bad attitude, that you made mistakes, so on and so forth. So, how do you prove that your layoff was unlawful? By getting the right lawyer to prove all this stuff that we just talked about. If you know a little bit about employment law, you might be asking yourself, well, what about the WARN Act, Branigan? The Worker Adjustment, Retraining, and Notification Act of 1988 is a federal law that says if an employer wants to do a mass layoff, they have to notify the affected employees 60 days in advance. But this law only applies to certain employers and it only applies in certain circumstances. And the goal of this law and similar warning type laws at the state level are generally meant to give workers and their families transition time to adjust to the future loss of employment. But if your employer violates this law, should you automatically run out and call a lawyer? No, not at all. This law doesn't really impact whether your layoff, your termination in and of itself is unlawful. It just outlines some minor penalties if the company fails to comply with certain procedures. Employment lawyers like me, who represent individual workers in wrongful termination type cases, aren't concerned with WARN Act violations very often. But if there is an egregious violation that affects a lot of employees, you should call a lawyer to see if a class action is appropriate. What's more important to talk about is severance. What about severance? In many layoffs, the company offers employees a severance package. And the basics of severance is that the company is offering you money in exchange for your signature on a document. And that document is a contract in which you give up your employment rights to sue the company. Now, just because they're offering you severance does not automatically mean that your layoff was unlawful. In many cases, accepting the severance package is the correct move and a no-brainer. But if you've been fired because of a protected characteristic or because you engaged in some kind of protected activity, and you believe that you have evidence to show that, then don't sign that severance agreement until you first get your case evaluated by an employment lawyer in your state. I've probably reviewed 100 cases where somebody signed a severance deal for like $5,000 or $20,000, but once the full story was revealed to me, their case was probably or actually worth hundreds of thousands of dollars, and now they can't recover that full value because they rushed to sign that money deal, that severance deal. Don't make that mistake. If you feel like your termination included some funny business, call a lawyer before you sign your severance agreement. At this point in the video, you might be wondering, if my layoff was unlawful, how much money is my case worth? Well, the honest answer is that it depends. It depends on a multitude of factors and circumstances that I've covered extensively in other videos. So if you really want to get an idea of how damages work in employment law, you should watch my video, How to Get a $1 Million Settlement. I go deep in that video as to why some lawsuits are worth millions of dollars and why some get dismissed for nothing. I recommend you watch every second of it. To summarize this video, the key to proving that your layoff was unlawful is to prove that you were actually fired because you engaged in a protected activity or because you are a member of a protected class. You will have to prove that the company lied about laying you off and you were actually fired or selected for firing because of one of those unlawful reasons. And if you believe that you were fired unlawfully, call a lawyer in your state. The free consultation process at my office is for California workers who got fired and they believe that they have a case for harassment, retaliation, discrimination, or wrongful termination. If that applies to you, please call me for a free consultation. I hope this video was helpful. Take care.